Fear, emotional strain, and terror of the victim during the events leading up to the murder may make an otherwise quick death especially heinous, atrocious, or cruel. Alex Zaldivar was already lying down in the living room when Brianna was brought in at gunpoint. In May 2012, 4 months previously, Alex had been laid down on the same floor in the same house when the home was robbed. Testimony suggests he suspected that there was some connection. Alex knew that the trial in the case was to start the next day and that he was a witness. Alex lay there as Brianna was brought in and laid down next to him, head to head. Subsequently, Remington was brought in and laid down next to him. As Alex lay there, with each successive person being retrieved and placed next to him, Alex had to wonder what was happening. His anxiety would have been building. When the question started coming, who is the naked guy? Where's the other dudes? Alex's suspicions had to connect the prior home invasion with this one. During the May home invasion, the hands of the victim were tied behind their backs. On this occasion, Alex apparently put his hands behind his back. What could that mean? Testimony presented during the course of the trial suggested that Alex was willing and even anxious to testify against those who had committed a crime against him and his friends in May of 2012 at this very same house. He was set to testify the next day. At some point in the course of the events, on the morning of the murder, testimony demonstrates that it had become apparent to Alex, as it had to Brianna, that their willingness to be witnesses in court the next day was the reason that they were lying on the floor about to be murdered. While Brianna may have retained some hope that some of what was happening was a bluff, any such thoughts in Alex's mind must have dissipated when the first shot was fired, hitting Brianna. Any questions about what that meant had to be answered when they heard the attackers say, quote, "Someone is going to die tonight," unquote. At that point, there would be no question in his mind. Alex's breathing changed. A gunshot was heard. Any doubt about somebody getting shot was now gone. It was not a matter of if, but when. Was he going to be next? Remington Campos testified at trial that he was lying next to Alex. Remington was 5 to 6 inches from Alex to the right. He could see Alex's face. Alex looked like he was tied up with his head on the ground and his hands on his back. His nose was flat on the floor. Remington testified that after Brianna was shot, Remington turned to look at Alex. Remington observed Alex's breathing change to a heavy breathing, such as hyperventilating, directly into the floor. Remington demonstrated to the jury and the court exactly what he had heard and seen in describing the breathing. He described Alex as just panicked, and he was dreading or preparing for what was coming, just making, and Remington described what he was talking about, straight into the floor, and he was bracing himself. Clearly, Alex was aware that he was going to die, that Brianna had just been shot, and that he and Remington were next, but he did not know which. As Remington said, Alex was preparing to die. He knew what was coming. He knew his friend Brianna had been shot. He knew the intent was to kill everybody. Somebody had asked, quote, "Did they miss?" unquote. And yet he could do nothing except lie in wait for his life to end with a gunshot. The court cannot speculate on what he was thinking, but must rely on what was reported by the witnesses, Brianna and Remington, who were there and who testified. This was not the situation where somebody was shot from seclusion and the victim does not know it was coming. It was not even a situation in which somebody is confronted with a person wielding a weapon and had an opportunity to try and talk that person out of it or even attempt to defend himself. This was a situation in which a victim was laid helpless on the floor with 2 other victims, was told that somebody was going to die, had it reaffirmed when he heard the latex gloves being placed on the hands of the assailant, had it reaffirmed when one of the victims was in fact shot, and had it reaffirmed when somebody asked, "Did you miss?" The testimony demonstrated that Alex did know he was going to die, but was forced to wait, not only to see when, but also to have to watch his friend Brianna shot before him. The fear and emotional strain was evidenced from Remington's observations of Alex prior to Alex's death, as he lay there on the floor. The immediate circumstances surrounding Alex's death demonstrated the torturous anxiety and fear of impending death. There were some cases cited in the memorandums, and the court addressed those in his memorandum. Unlike Mr. Knight and Mr. Krause in the Rimmer case, Alex knew that he was going to die. He had been told that by the assailants, and he had seen and heard Brianna shot. The circumstances surrounding the placement of the victims, the comments made by the assailants, the duration of time during which it took, the location of the attack, the circumstances related to the prior crime that was set for trial and about which they were going to testify as essential witnesses, and the actions of the assailants suggest beyond a reasonable doubt that Alex was aware of the impending death. It was not a matter of would he die, it was when. Alex witnessed what he thought to be a murder of Brianna in the same room within inches of his placement. It is apparent that Alex experienced fear and terror prior to his death. While death by gunshot is generally instantaneous, a finding of HAC does not usually follow unless the shooting is accompanied by additional facts resulting in mental or physical torture to the victim. Here, we have similar facts described by an eyewitness, Mr. Remington Campos, who was inches away. This aggravator has been proven beyond a reasonable doubt. The factual circumstances support the aggravator of heinous, atrocious, and cruel, and the aggravator is given great weight. The next aggravator that the state seeks is that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The state has asserted as an aggravator the cold, calculated, and premeditated, and that it was without any pretense of moral or legal justification. To prove the aggravator beyond and to the exclusion of a reasonable doubt, the state must show more than simple premeditation. It must show that it was not the result of an emotional outburst or committed in a fit of rage or even in response to panic. The state must also prove that it was committed with some pre-planning or pre-design and orchestrated according to a plan with no pretense of any legal or moral justification. The evidence as a whole demonstrates this to be a plan to eliminate witnesses by execution who were expected to testify against Bessman Okafor and Nolan Bernard regarding an armed home invasion robbery that took place on May 9, 2012. The witnesses to the home invasion were Brianna Campos, Brandon Campos, Alex Zaldivar, and Will Harrington. Each was supposed to testify at trial and was set to commence on September 11, 2012. Each had had their deposition taken in preparation for that trial on August 23, 2012. The testimony of the events preceding the murders lays a pattern of the cold, calculated, and premeditated nature of this crime. The day after the deposition, Idoria Ruffin, Mr. Okafor's brother, was involved in a text exchange concerning a request to obtain weapons. The text includes a statement by Mr. Okafor that the witnesses were going to show up to testify against him and Mr. Bernard. The exchange occurred 18 days prior to the murders. The day prior to the murders, Mr. Okafor conducted an internet search that I've referenced earlier about how do you remove gun residue in this matter. On the evening of the incident, Mr. Okafor asked Mr. McLaren to get some things for him to come over to his house where Mr. Okafor was staying. Mr. McLaren knew this to be Takithia Ruffin's house. Mr. McLaren believed that Mr. Okafor wanted him to get items because Mr. Okafor was on house arrest. These items requested were a hoodie and some gloves, which Mr. Okafor said he needed that night. While Mr. McLaren did not obtain the items from Mr. Okafor requested, he did go to the house. Mr. McLaren described Mr. Okafor as nervous about the upcoming trial. Mr. Okafor advised him that it looked like everybody was going to show up for trial to testify, and Mr. Okafor was afraid about going back to jail. He expressed the feeling to Mr. McLaren that he hoped they would not show up, and noted that he could not let them show up. Mr. McLaren told Detective Moreschi at a post-shooting interview that Mr. McLaren said he, quote, can't let them make it to trial, unquote. The record also shows that Mr. Okafor not only planned, but also meticulously arranged the killing and attempted killings. Evidence demonstrated that he recruited Nestle Cicerone to assist as a lookout. Mr. Cicerone testified at trial under a plea agreement, which the court has reviewed. He also testified at the previous trials of co-defendants Emmanuel Wallace and Donnell Godfrey. The court found his testimony to be believable and consistent not only with other facts and evidence in the case, but also, for the most part, with his testimony at the prior trials. Mr. Cicerone noted that Mr. Okafor had expressed concerns that the witness was going to testify against him at trial. He recalled that Mr. Okafor knocked on his door late at night and implied that he needed help to serve as a lookout. Mr. Okafor told him to take Mr. Cicerone's friend's car and to follow him. Mr. Cicerone testified that he did not know where he was going or why. He was told that if you see anything, call him from his phone. Mr. Cicerone explained that anything suspicious meant to him a police car. Mr. Okafor provided the directions as to what to do, when to do it, where Mr. Cicerone should position himself, and instructions as to how to do it. Sharia Gordon was also recruited by Mr. Okafor. Mr. Okafor had fathered at least one of her babies. She knew Mr. Okafor was out on bond. She received a phone call in the early morning hours of September 10th telling her to get ready as he was going to pick her up. She also did not know what was going on, but did as she was told by Mr. Okafor. She followed the directions and drove to where she was told. Mr. Okafor ordered her to a certain place, different from Mr. Cicerone's, and told her to watch and listen for sirens. Sharia Gordon also testified under a plea agreement. She testified at the previous trials in this matter. Ms. Gordon clearly gave previous conflicting versions of events to the police officers prior to any of these trials. However, at each of the trials in this matter, her testimony was consistent with the evidence and testimony provided by other witnesses. The court found her testimony to be believable and consistent. It was Bessman Okafor who contacted each person and arranged for them to serve as lookouts. And it was Bessman Okafor who was to be called by each of the lookouts if they saw or heard anything out of the ordinary. Mr. Okafor also arranged for and orchestrated which vehicles would be taken. He told Nestle Cicerone to use Tony Nelson's white Ford Taurus. He selected Takithia Ruffin's white Malibu. The third vehicle used was Candace Ruffin's white Impala. After they rendezvoused at the abandoned house, Bessman Okafor left in a car headed to the victim's house. When Mr. Cicerone was going to his lookout position, it was Mr. Okafor who directed him and told him to stay there at that particular spot. The evidence also shows that a box of rubber gloves was found in the vehicles that were involved. Testimony by two surviving victims was that they heard rubber gloves being pulled on just prior to the shootings. Phone records over the 10-hour period of time surrounding the shootings demonstrated communications between and amongst Bessman Okafor's phone, Manuel Wallace's phone, and Donnell Godfrey's phone. The ownership of the phones came into question. However, the testimony was clear as to which phone was being used by Mr. Okafor. Testimony also demonstrated that Mr. Okafor was monitoring his time away from home confinement and his electronic monitoring station. He had explained to Mrs. Cicerone the timing of the ankle monitor. Taken as a whole, the testimony proves beyond a reasonable doubt that it was Mr. Okafor who controlled what was said, what was done at the house and at the time of the murders. The questions asked clearly point to someone who was involved in the May robbery burglary, and Mr. Okafor would have been the only one that was not incarcerated who would know that the two of the victims of the May robbery were not present at the house on September night. And similarly, Mr. Okafor would have been the only one to recognize that the naked guy would not have been at the original robbery. The plan to execute the witnesses was not a spur-of-the-moment idea or even one arising out of a sudden panic. It was a well-orchestrated scheme involving the obtaining of weapons, the recruiting and placement of lookouts, the coordination by cell phones amongst the assailants, and the coordination of the timing so as to circumvent the electronic monitoring. What can be greater evidence of the coldness of the acts than to tell the victims who are lying on the floor helpless that someone is going to die tonight. The expression could only be explained by a desire to make the victim suffer, knowing one or all will die, but not knowing when or how. There can be no pretense of any legal or moral justification. The only purpose was to silence witnesses from testifying, and the only individual who was threatened by the testimony of these targeted witnesses and was able to put the plan in place and to execute it was Bessman Okafor. The court finds that the state has met its burden of demonstrating this aggravator beyond and to the exclusion of a reasonable doubt, and the court gives this aggravator great weight. The defense provided evidence of mitigation. Defense counsel noted that he was not seeking any statutory mitigating factors that were being raised. However, 27 other mitigating factors had been set forth in the defendant's amended sentencing memorandum. The law requires the trial court must expressly evaluate in writing each proposed mitigating circumstance and determine whether each factor is supported by the greater weight of the evidence, and if so, whether it is truly mitigating. The test is two parts. Has it been proven? And if so, is it truly mitigating in this case? Florida Statute 921.141(6)H sets forth the following, quote, the existence of any other factors in the defendant's background that would mitigate against imposition of the death penalty. Some of the enumerated non-statutory mitigating factors could be considered to fall under this subparagraph. Counsel for Mr. Okafor presented multiple witnesses in mitigation. Generally, it has been shown that Mr. Okafor experienced a difficult early childhood. All will be discussed below, or as will be discussed below. He lacked a stable home, was in need of assistance with school, which he did not receive, was economically disadvantaged, was punished severely and probably inappropriately, lost his father, was raised by a mother who appeared to have significant social problems as well as other problems, was sexually abused by someone who was thought to be a person that could be trusted, and lacked a role model. Without attempting to restating all the testimony or even review all of the witnesses, an overview of some of the key point testimony in mitigation is important. The defense called James Okafor. Mr. James Okafor was identified as the High Chief where he lived in Nigeria. He was the father and grandfather of many, but of import in this case, he was the father of Charles Okafor, who was the father of Bessman Okafor. He had never met with, spoken to, or communicated in any manner with Bessman Okafor at any time prior to the trial. He only knew that his son Charles had a son named Bessman, and he believes he saw a photo of him. He did not offer any information about Bessman Okafor. Eurisha, and I know I'm saying that name wrong, Okafor, was also called by the defense. She is the only daughter of the High Chief James Okafor. She describes Bessman as being her nephew. Ms. Okafor has never met Mr. Bessman Okafor before 2012. She had absolutely no contact with him when he was younger. In fact, until the trial, she had never met Bessman and had only spoken with him by phone. Apparently, she had planned to have Bessman go to Nigeria with her, but he never did because he was arrested and jailed. She did not offer much relevant information about Bessman Okafor that the court found applicable to the issues herein. Trenton James was also called as a witness. Trenton James is the younger brother of Bessman by 4 years. Mr. James provided some early family information. The family consisted of 3 brothers, Trenton, Brenton, and Bessman, and 2 sisters, Takitha Ruffin and Candace Ruffin. There were also 2 fathers, or stepfathers in this household, Akpin James, his father, and Trevor Sinclair. His mother was Catalina Ruffin. Trenton described Akpin James as never really living with the family, although Trenton did have some bond with him. Trenton Sinclair was described as one who never did anything with the family and was drunk frequently. Catalina and Trenton would fight a lot, and he would beat her frequently. Of importance is that Bessman was described as being scared of him. Trenton testified that Catalina regularly punished Bessman by whipping him. He describes Bessman's beatings as more than those received by the others. Bessman would be beaten with a belt, switches, and even electrical cord to the point of leaving marks. Sometimes he was required to strip naked for the whippings. Trenton James' testimony also described Bessman as a very young boy being scared from the whippings. There were occasions when others would get presents at Christmas, but Bessman would not. Testimony suggests that there were times when the family would not have enough food and that they wore old clothes and shoes and were teased in school. Trenton James' testimony was historic. He could provide no information as to how Bessman was treated in middle or high school or thereafter. He did note that Bessman had gotten into trouble in school. Lastly, on cross-examination, Trenton noted that while he lived in the same house as Bessman for a period of time, he, Trenton, had never committed a felony and had never been in prison. The defense retained Dr. Stephen Gold, a PhD psychologist. Dr. Gold is a professor at the Nova Southeastern University. He's a psychologist who specializes in trauma-related difficulties with an emphasis on adults who have been abused as children. He indicated that he had conducted a forensic examination with Bessman Okafor, but not a clinical exam. Dr. Gold cited to various studies, including the Adverse Childhood Experience known as the ACE study. He noted that Bessman Okafor had been exposed to 9 out of the 10 risk factors, which is very rare. These factors will be considered hereafter as they make up many of the mitigating factors that are raised by Mr. Okafor and presented to the court. When asked, are you saying, you're not saying, are you, that because of the existence of these factors is the cause of Mr. Okafor's legal problems, he responded, no. Dr. Gold agreed that his focus was not to diagnose Mr. Okafor. He did opine that Mr. Okafor had an impaired ability to restrain his impulses, a heightened likelihood of acting aggressively, and an impaired ability to think things through, some language impairment, difficulty in expressing himself and understanding other people, and an elevated anxiety level, and may miss social cues. Trevor St. Clair testified. He was married to Catalina Ruffin Sinclair. While Bessman was not his son, he kind of adopted him. Mr. Sinclair confirmed that a member of their church had sexually assaulted Bessman as a young boy. He talked about it as a little with Bessman, but they were not successful talks. Marcia Pete was also called to testify. She was married to the late Charles Okafor in 1983. She first saw Bessman Okafor when some lady dropped him off at her mother's house with limited items and clothes, but lots of underwear. She referred to Bessman as her, quote, son, unquote, and took him home to live with her for a while. She described him initially as quiet, staying to himself in the room. He appeared to be normal and physically developed, but surprisingly was not potty trained. He could not read and write. She worked with him to improve in skills. She describes babying him because she indicated he seemed to need it. Bessman went home to his mother for the summer, but was never sent back to Miss Pete. For reasons unknown, Miss Pete indicated that Bessman's mother, Catalina, did not want her to see Bessman again. Her husband, Charles, had obtained his BA and was working on his master's when he was killed in an auto accident. She had not known that Charles had a family or a son. To her knowledge, Charles did not travel to see Bessman in Florida after Bessman went home for the summer. Catalina Ruffin Sinclair testified. She is the mother of Bessman Okafor, and he is her oldest son. She testified that she and Charles, the father of Bessman, lived as a family. They parted ways when Bessman was 2 or 3 years old. Catalina described Charles as a good father who stayed in Bessman's life and was a hard worker. When Catalina and Alpin James moved to Apopka, Florida, the other children did not like Bessman, so they left Bessman with Marcia Pete. She noted that they had a lot of money problems, not enough food when the kids were growing up. They received public assistance. Mr. James had an alcohol problem and would hear her when he was drinking. Her next husband was Trevor Sinclair, and he would drink a lot and fight with her. Some of this occurred in front of the children. She noted that Mr. James would not spend much time, if any, with Bessman. She admitted that Bessman never had a father figure in the home. Miss Sinclair did involve herself in praise steppers. a church group. A member of her church named Brother Reese would serve as Bessman's mentor. She admits that Bessman was sexually abused by Mr. Jeffers, another member of the church, but she never arranged for counseling. Mrs. Sinclair testified that she would take the children, including Bessman, to church until they got older, including Bible studies and Sunday schools. She admits to, as she describes it, whooping the kids with belts, extension cords, and switches to discipline them. She was arrested for aggravated child abuse involving the children and Bessman. Bessman was punished a little more than the others because, according to her, he got into more trouble than the others. This was before the incident with Mr. Jeffers. As a child, she received whoopings for getting out of line, so she did as her parents did. Bessman had a daughter, Brianna, who had multiple surgeries but passed away recently. He also had a son by Pearl Wallace. The son died of SIDS at a very early age. Miss Ruffin Sinclair indicated that she always had a job outside of the home, and she noted that she loves her son. Many of the mitigating factors were grouped together by the defense in the memorandum, so the court has grouped those together in responding to them. The first mitigating factor alleged, or mitigating factors alleged, are there was insufficient evidence presented to prove that Bessman Okafor fired the fatal shots and that the defendant didn't enter the victim's home. Mr. Okafor argues that there was insufficient evidence that he fired the fatal shot or that he was even in the house. This position contradicts or ignores the enormous amount of evidence presented during the course of the trial. The overwhelming evidence is that Mr. Okafor was the individual who originated the idea of committing the crime, orchestrated the plan for committing it, participated in the crime, and was the major player in the murder and attempted murder. Mr. Okafor was the only person out of jail who would benefit from the elimination of the witness. His only co-defendant, Nolan Bernard, was in jail at the time and could not have participated in the crimes. Mr. Ciceron and Ms. Gordon testified as to Mr. Okafor's arranging and recruiting of their personnel for the murders. They placed Mr. Okafor in the car going to and from 503 Bernardino Road. Agent Fleck placed the use of cell phones, including the one used by Mr. Okafor, in the location of the home at the time of the murders. Questions asked by the intruders could only have been known by individuals who were involved on the May 9, 2012 home invasion. Mr. Okafor was the only one who could have been at the house on September 12, 2012 that would have had the information about the May 9th incident. The three defendants who committed these crimes on September 12, 2012 were all armed. Each of the two defendants, Emmanuel Wallace and Donnell Godfrey, were shown to be using a weapon other than a revolver. One was carrying a Glock and the other an assault rifle. The slugs removed by Dr. Hansen from Mr. Zaldivar and examined by the FDLE firearms specialist were shown to be most likely from a .38 caliber revolver, or at least a .38 caliber type. No shell casings were found at the scene, items that could have been present if a should have been present if a semi-automatic had been used. Comments made before the shooting, leading up to it, and afterwards all point to Mr. Okafor and only Mr. Okafor. The court finds that the mitigating factors of insufficient evidence were as present to prove that Bessman Okafor fired the fatal shot and or that Mr. Okafor didn't enter the victim's home has not been proved by either the greater weight of the evidence or by the lack of the state's evidence. Having not been proven, these two mitigating factors are given no weight by the court. The next group of factors deal with four. Co-defendant Emmanuel Wallace was sentenced to life. Co-defendant Donnell Godfrey was sentenced to life. Sharia Gordon will be sentenced to term of years. Nestle Ciceron will be sentenced to a term of years. Mr. Okafor treats four individuals together for the purpose of this mitigating factor and states that, quote, the exact roles of Okafor, Godfrey, and Wallace are unclear, unquote. The evidence shows to the contrary. Sharia Gordon and Nestle Gordon were at best lookouts. There is no evidence that they were involved with the planning of the crimes. Both were solicited to assist by Mr. Okafor. Neither was at the place of the actual crime. Both agreed to testify, albeit in exchange for reduced sentences, but only if the court believed their testimony to be complete, true, and accurate. Mr. Cicerone testified that he was asleep when Mr. Okafor woke him at the home, told him that he needed his help, and directed him as to what car to take and to be a lookout. Mr. Okafor directed him where to go, what to do, and how to do it. Mr. Okafor gave him Mr. Wallace's phone, told him to call if he heard anything. Mr. Cicerone was clearly not the organizer, the instigator, or the active player. His role, compared to Mr. Okafor's and even Mr. Wallace and Mr. Godfrey's, was significant but comparatively minor. Like Mr. Cicerone, Ms. Gordon's involvement was also as a lookout. Mr. Okafor called her early in the morning on September 10, 2012, and told her, "Get ready, I'm coming to pick you up." She testified she did not know what was going on. At the gas station, she was told to pay for the gas, then to go down the road, park the car, and serve as a lookout, and call Mr. Okafor if she heard anything. Towards the end, she went back to the abandoned house to pick up Donnell Godfrey, as she was told to by Mr. Okafor. Her role was secondary to any of the actor players, and certainly not as an organizer of this crime. Emmanuel Wallace and Donnell Godfrey were each indicted in this matter. Each was tried to verdict in front of a jury, and each was convicted by a unanimous jury. The state of Florida elected not to pursue the death penalty as to either. Each, after conviction, was sentenced to life in prison, the maximum penalty allowed under the law. Unlike Mr. Cicerone and Ms. Gordon, both Mr. Wallace and Mr. Godfrey were found to be actively involved in the murders, attempted murders, and burglary. Each was at the house. Each was identified with a weapon, and as found to be by both juries, each was found to be responsible for the crimes. The involvement of each was significant, active, and participatory. However, unlike Mr. Okafor, there is no evidence that they devised the scheme to commit these murders. Further, they were not shown to be the ones who had direct vested interest in the witnesses appearing or not appearing at the trial on May of 2012 robbery and burglary charges. There is almost no evidence that they were involved in organizing, arranging, or coordinating this attack. Mr. Okafor alone was the one who created, organized, recruited, and directed the execution of the crime. He clearly was involved in every phase of the preparation, execution of the series of events that led to the murder. There has been no evidence that Mr. Wallace or Mr. Godfrey had any involvement in the detailed planning. Mr. Okafor researched the internet, apparently obtained latex gloves, recruited Mr. Cicerone and Ms. Gordon, organized Mr. Wallace and Mr. Godfrey to assist with the murder and attempted murder. He was the one to whom the lookouts would report. He instructed each as to who would ride with whom, both before and after the attack. Mr. Okafor was the individual who requested the clothing from Mr. McLaren and told Mr. McLaren, "I can't let them show up." Mr. Okafor was also the one who clearly exercised the most influence on the participants. The testimony of Ms. Cicerone and Mr. Cicerone and Ms. Gordon demonstrates that Mr. Okafor gave the orders. "I want your help. Take Tony Nelson's car. Get ready, I'm going to pick you up. You are the lookout. Call me if you hear sirens." It is also absolutely clear that not only did Mr. Okafor receive the greatest benefit from the murder, he was the only one outside of jail who received any benefit from the murders of these witnesses. At best, Mr. Wallace and Mr. Godfrey were present and armed, but they were not armed with the type of weapon that killed Mr. Alex Zaldivar. Neither of them carried the type of weapon that was consistent with the shootings that took place. They were also not subject to electronic monitoring with an ankle monitor, as Mr. Okafor was. Neither Mr. Wallace nor Mr. Godfrey had to devise a method to defeat the electronic monitoring or develop a time schedule that would take advantage of the lapses in the monitoring. The murders in this case have been shown to be those concocted, planned, implemented, and executed by Mr. Okafor. Mr. Wallace and Mr. Godfrey were clearly involved, but only as assistants in the actual commission of the murders. The court has not sentenced Mr. Cicerone or Ms. Gordon as of the date of this order. The court has sentenced Mr. Wallace and Mr. Godfrey to life in prison. The reasons set forth above, the court gives little weight to these factors. The next factors grouped together are as follows. Bessman Okafor was born with a learning disability. Bessman Okafor's learning disability was never treated in school, despite treatment being available and useful. and this untreated learning disability made it difficult for him to be successful in school. Mr. Okafor asserts he suffers from a learning disability that was never treated. He relies primarily on the testimony of Dr. Taylor and Marcia Pate. Dr. Taylor is a child and adolescent psychologist and not an adult psychologist. His opinions were based on assessments from the 5th and 7th grade records. He had not interviewed Mr. Okafor. The records suggest that in the 5th and 7th grade time frame, there was evidence of a language-based learning disability. Dr. Taylor was unable to render an opinion on the current status of Mr. Okafor, of Mr. Okafor's learning disability, and therefore had no opinions as to his current disabilities, if any. Prior assessments and comments in the 5th and 7th grade demonstrated that he was acting out, his behavior was becoming very difficult, he had an explosive temper with his peers, and he would lose control of his emotions and hit other students. The notes of May 2003 suggest that his conduct had become more serious and that he had been in a fight that had been a major disruption to the school. Dr. Taylor confirms that from the records by late middle school and high school, Mr. Okafor's behavior was possibly much more serious. Maria Pate cared for Mr. Okafor when he was very young, approximately 3 or 4 years of age. She treated him like her own son. She testified that when he came to stay with her, he was not potty trained. He was very quiet and stayed in the room a lot. When he first came to her house, he was not able to read and write, but she tried to teach him. Once he went back to his mother, she had no further contact with him. The evidence suggests that as a child, Mr. Okafor probably did have a learning disability, which might not have been appropriately addressed. However, there was little to no evidence to suggest the present abilities or disabilities. There was also little to no evidence as to how these childhood problems manifest themselves at the present time in Mr. Okafor or during the time frame involved in this particular case. The court finds that these mitigating factors have been shown to have existed in early childhood, but have not been shown to have had any effect on the matter before the court. The court, however, has given some weight to these mitigating factors. Next asserted are a series of 3. Mr. Bessman Okafor was not toilet trained as a toddler. Mr. Bessman Okafor was abandoned at a stranger's doorstep. Mr. Bessman Okafor was kept away from his parental family by his mother. Mr. Okafor argues the delayed toilet training and the abandonment and being kept away from his mother should be considered as mitigating factors. The testimony presented noted that when he was left with his father's wife, Marisa Pete, he was not potty trained. The age is unclear, but from the testimony, but it appears that he might have been 3 or 4. Either way, the testimony suggests that Ms. Pate either attempted to or did remedy that issue in short time. The testimony seems to suggest that Mr. Okafor, as a child, was left with his father's new wife's mother until Ms. Pate could pick him up. Then he lived with Ms. Pate for a period of time until he was returned to his mother. There was no showing of what effect, if any, this exchange had on Mr. Okafor, or even if he still remembers it. Mr. Pate remembers treating Mr. Okafor as her own son and babying him more than the other children. There has been no testimony as to any ill effect caused by placing him with Miss Pete or the manner in which it was done. In fact, the contrary is probably true. Taken as a whole, it appears that Miss Pete may have had a very positive effect on Mr. Okafor. Lastly, in this group of mitigating factors, it is alleged that Bessman Okafor was kept away from his paternal family by his mother. There has been no evidence that the paternal family sought to have Bessman Okafor with them when he was very young, or at least until he was placed with them by his mother, transferring the child to the mother of Miss Pate. In fact, the testimony is that Miss Pete did not even know that her husband Charles had a prior wife or family. Even when she learned that he had been previously married and divorced, she was not told that her husband had a son by a prior marriage. There was testimony that once Mr. Okafor was returned to his mother, Catalina Ruffin, she was reluctant to send him back to visit to stay with Miss Pete. However, there was no testimony that Charles Okafor requested that Bessman be returned to them. There was, however, testimony that after Mr. Bessman was returned to Catalina Ruffin Sinclair, Charles did not make any effort to travel to Florida to see his son. Mr. Okafor contends that his poor upbringing resulted in him becoming a dysfunctional adult. However, there is no showing that such a result occurred in this specific manner. Mr. Okafor may well have had a better upbringing in a different family, but that would require the court to speculate and make assumptions as to what might have happened and how it might have affected Mr. Okafor. The defense also argues that the state breached its duty to step in by, quote, failing to intervene when the horrendous treatment of Bessman Okafor was brought to its attention on multiple occasions, unquote, and therefore may be partly responsible for Mr. Okafor's present difficulties. No showing of any duty or breach of duty by the state has been presented. Further, there is no showing that if any action had been taken, the outcome would have, could have, or might have been different. While it is true that Mr. Okafor had a difficult upbringing and may have had a slight delay in potty training and lived with the mother instead of the father, there has been no showing that any of these circumstances contributed to or caused Mr. Okafor's actions that are the subject of these charges. The court will give these combined mitigating factors some weight. There are 5 items that are grouped together in this next mitigating factor. Bessman Okafor grew up with poor role models. Bessman Okafor suffered regular bullying at school. Bessman Okafor moved home and schools often. Bessman Okafor lacked psychological care and treatment. Bessman Okafor was treated differently than his siblings. Mr. Okafor lumps together these 5 mitigating factors, some of which relate to matters previously addressed and some that relate to matters that I will address at a later point. In summary, he argues that he moved schools a lot because he moved homes, was bullied in those schools, and had poor role models which he could look to. He also argues that he was differently from his siblings and that he lacked psychological care and treatment. The testimony demonstrates that Mr. Okafor did, in all likelihood, have a poor or non-existent role model. His natural father did not raise him. His fathers either ignored him or punished him, and when he was taken under the tutelage of a member of his mother's church, he was abused by at least one member. Testimony in the record from his brother suggests that Mr. Okafor was bullied in school, but he also that he got into a lot of trouble. Some of this was confirmed in school records as testified to by Dr. Taylor. His brother, Trenton James, also confirmed that they transferred schools a lot. He confirmed that Mr. Okafor was treated differently than his siblings by being punished more often and maybe more severely. The testimony and evidence suggested that as a child, Mr. Okafor may well have benefited from treatment or counseling for a psychological or remedial education nature. However, there is a dearth of evidence as to what, if any, effect it would have had on Mr. Okafor's present status or his emotional or mental status at the time of the crimes were committed. Dr. Gold was not able to provide testimony on these matters, and Dr. Taylor dealt only with Mr. Okafor's early years based on the records available. In sum, the evidence does support portions of these mitigators, and the court will give them some weight. ACE results is the next. ACE results shown anxiety, aggression, and poor impulse control. This is one of the mitigators that's set forth. The defense relies on Dr. Gold and the results of his analysis utilizing a study known as the Adverse Childhood Experience, the ACS, referred to as that study. Mr. Okafor suggests that the study confirms that he suffered from anxiety, aggression, and poor impulse control. However, Dr. Gold testified that he was not saying the existence of any of these factors was the cause of Mr. Okafor's legal problems. While he noted that Mr. Okafor suffered from anxiety, he also noted that it could be either situational or constant, and that it could have been just manifested during the interview. For example, he noted that when the conversation turned to sexual abuse, Mr. Okafor's anxiety did spike. Dr. Gold confirmed that he did not interview or speak with Mr. Okafor's friends or people with whom Mr. Okafor would have associated on a daily basis prior to these crimes, and that such might have given him important information regarding the alleged anxiety. Dr. Gold confirmed that Mr. Okafor is not in chronic terror, does not suffer from depression, has not suffered from substance abuse, does not have an eating disorder, has no psychosis, and does not show evidence of suicidal ideations. Dr. Gold noted that Mr. Okafor has an impaired ability to restrain his impulses and has a heightened sense of acting aggressively. However, the crimes charged in this matter were not impulsive. They were clearly planned and mapped out over what appeared to be a course of time. The actions described by the witnesses, the victims, and the physical evidence suggest actions that are anything but impulsive. While Mr. Okafor may well have poor impulse control, such was not a factor in the manner and method with which the criminal acts were undertaken in this case. Anxiety may well be a factor, but it has not been established what type of anxiety or the cause of it or how it manifested. As noted, anxiety may be situational or chronic. At the time of Dr. Gold's interview, Mr. Okafor had been sentenced to life in prison and was facing a trial in which the death penalty had been requested by the state. Faced with such situations, it would not be surprising that Mr. Okafor presented as anxious at the time he was evaluated. Clearly, aggression was a factor. It was present during the elementary school and possibly middle school. The crimes here suggest aggression. The issue was not answered by the witnesses. The issue not answered by the witnesses was whether the aggression in this instance was based on a desire to get even with the witness or merely to prevent the witness from testifying or for some other reason. The court finds that this mitigating factor, at least as to the aggression, has been proven and is given some weight. Even if impulsivity and anxiety have been shown in relation to something other than the present circumstance, the factor would still be given some weight. Bessman Okafor suffered the loss of a son and a daughter. That is the next mitigator in this matter. Testimony presented and confirmed that Mr. Okafor has lost 2 children. Ms. Catalina Ruffin Sinclair testified that Mr. Okafor had a daughter named Brianna. The young girl apparently had a significant medical conditions which required even organ transplants. The testimony suggested that she died recently, although that was not more fully defined. There was little, if any, testimony as to Mr. Okafor's relationship with his daughter, how often he would have contact with her, if at all, what the contact involved, the quality of the contact, or any other specifics about either the relationship between the child and the father or the effect of her death had on him. The timing of the death in relation to this incident was not even apparent from the testimony. Ms. Ruffin Sinclair also noted that Mr. Okafor had a son who died at a very young age. The suspected cause of death was sudden infant death syndrome. Once again, the relationship, if any, the degree and quality of the relationship, the type of contact, if any, and the time frame was not disclosed. Loss of a child or children can be devastating. However, the type of effect it can have depends on the relationship, frequency, and degree of contact, and the quality of the relationship. The record is devoid of specific information as to any relationship or the effect of that relationship and subsequent loss of the children had on Mr. Okafor. By the testimony that was given, it was established that Mr. Okafor had 2 children who died. Without more, the court can only give some weight to this factor. Mr. Okafor suffered the loss of a parent to death, divorce, or separation. Catalina Ruffin Sinclair testified that Charles Okafor was a good father to Bessman. They broke up when Bessman was 2 or 3 years old. Charles stayed in Bessman's life until Miss Ruffin Sinclair moved from Louisiana. She did not explain what, quote, staying in his life, unquote, meant, nor did she clarify the extent of Charles' involvement. Testimony from Marcia Pate indicates that Charles Okafor died in a car accident after Bessman Okafor was sent to his mother, Catalina Ruffin Sinclair. There was significant testimony from Marcia Pate as to her activities with Bessman when he lived with her, but very little testimony as to the interaction between Bessman and his father. Ms. Ruffin's testimony that Charles was a good father and stayed with them until they moved must be balanced against Ms. Pete's testimony that Charles had never even discussed or mentioned the existence of Bessman Okafor. There was testimony that after Bessman was returned to his mother for the summer, Charles made no effort to travel to Florida to see his son. Once again, the lack of testimony regarding the interaction or lack thereof between Bessman and his father, and the lack of any testimony as to Bessman Okafor's reactions to his father's death makes it difficult for the court to assess the relationship of the loss. The loss of his father has been shown by both the death of the father and the fact that they were raised by his mother and was therefore separated from his father. However, the evidence does not suggest a specific impact that this has had upon him at any point in his life, and certainly not around the times of this event or leading up to it. The court finds that the mitigating factor has been proved and gives some weight to this mitigating factor. Bessman Okafor suffered physical abuse. Bessman Okafor suffered verbal and emotional abuse. Again, the two have been lumped together in this matter. The testimony is replete with evidence that as a young child, Bessman Okafor was abused verbally, emotionally, and physically. The physical abuse was severe. Catalina Ruffin Sinclair and Trenton Jones testified after the beatings, about the beatings administered to Mr. Okafor. They also spoke of the severity and frequency of the whoopings, which were administered with belts, extension cords, and switches. The records demonstrate that Bessman, on an occasion, was forced to strip naked and was whipped as a punishment. Both witnesses confirmed that he was beaten more than the other children. They also testified that the whippings left scarring. Ms. Ruffin Sinclair acknowledged that she was arrested for the aggravated child abuse and eventually placed on probation for it. The court finds that it has been proven that Mr. Okafor suffered verbal, emotional, and physical abuse as a young child. There was no testimony as to how long the abuse continued. In fact, Trevor Sinclair indicated that, to his knowledge, was limited to a period of time prior to middle school and high school. The abuse was severe and extensive at the times it was administered. However, the effect on Mr. Sinclair's later life, adolescence, and adulthood have not been established. The studies offer some suggestions, but not as to Mr. Okafor specifically. The court finds that these mitigating factors treated together have been proven and assigns it moderate weight as one mitigating factor. Bessman Okafor was sexually abused, and Bessman Okafor was not provided with counseling for his abuse. There can be no question but that Mr. Okafor was sexually abused as a child, and on probably more than one occasion. Testimony by Trevor Sinclair and Catalina Ruffin, as well as records introduced, confirmed that Mr. Okafor was sexually abused by an individual at his church. The abuser appeared to be a person of trust upon whom he was supposed to rely. It also appears that no counseling for the abuse was provided. The reason given by Catalina Ruffin is not totally clear, but is not significant. The end result is that Mr. Okafor received no counseling for his sexual abuse. The court finds that the prior sexual abuse of the defendant, Bessman Okafor, did occur when he was a child, that it was untreated, and that no counseling was provided. Dr. Gold references this event as one of the factors in the ACE scale and that can lead to long-term mental health consequences. However, he further testified that he was not saying that the existence of this factor or any other was the cause of Mr. Okafor's legal problems. The court finds these factors have been proven and treats them as mitigating factors and assigns significant weight to them. Bessman Okafor was emotionally neglected, and Bessman Okafor was physically neglected. These are the next two. As noted previously, Mr. Okafor was emotionally neglected as a young child. He was left with his mother at a very young age at his father's second wife's mother's home, where he came under what appeared to be the loving care of Marcia Pete. He was physically disciplined and not given the number of gifts others received at holidays, except as described by Miss Pete, where she did provide gifts to him at Christmas. On occasions, there was not enough food for him and his siblings, and they had to wear older clothes and shoes. In other words, they were poor. Although they did have public assistance. He did not receive the counseling for the sexual abuse, as I mentioned earlier. These two mitigating factors merge with other mitigating factors which have been addressed. To the extent that these two factors raise other issues that have not been previously addressed, the court finds that such matters deal directly with the socioeconomic status of the family and the side effects therefrom at the time of the childhood and should be given some weight. Bessman Okafor suffered domestic violence. The defense lists the mitigating factor in his memorandum but offers no comments thereon. Clearly, there was a domestic violence within Mr. Okafor's family. Testimony from Catalina Ruffin and Trenton James described violence between the mother and the stepfather. Trenton James, Mr. Okafor's younger brother, who lived in the same house and presumptively observed and experienced the same domestic violence amongst the grown-ups, noted that he had never committed a felony or been in prison. Mr. Okafor has. Dr. Gold did note that domestic violence is one of the ACE factors. He further opined that it appeared to exist in Mr. Okafor's family dynamics, at least while he was a young child. The court finds that apart from being an element of other mitigating factors, this is not a separate factor that has been shown to be a cause of problems for Mr. Okafor. The court finds that the mitigating factor was proven, but is part of other mitigating factors and assigns it little weight separately. A household member was an alcoholic. Testimony confirms that Mr. Okafor's stepfather, Alpin James, was an alcoholic. The evidence suggests that Travis Sinclair, also a stepfather, more likely than not drank in excess. It can be inferred that some of the physical, mental, and verbal abuse occurred, at least in part, as a result of the intoxication by members of Okafor's family. The evidence regarding the use of alcohol by household members related to Mr. Okafor's early years. There was no testimony that it continued on into his adolescent, teenage, or even early adulthood years. Further, there was no testimony save for the generalization from Dr. Gold that this household member's alcoholism played any part in Mr. Okafor's adult development or his actions in planning and committing the crimes charged. The court finds this mitigating factor was proven, but gives it little weight as an independent mitigating factor. Household members were incarcerated. Mr. Okafor suggests that other members of his family were incarcerated, and this has had an unspecified effect on him. He specifically points to his mother, Catalina Ruffin, who was arrested for aggravated child abuse, and to Alpin James and Trevor Sinclair, who may have been arrested while living in the household. Once again, Mr. Okafor cites to Dr. Gold and the ACE study. The court heard testimony from Trenton James, Mr. Okafor's brother. As noted previously, he lived in the same household with the same mother, with Alpin James and Trevor Sinclair. And unlike Mr. Okafor, he has never committed a felony and has never been in prison. The court finds that it has been proven that at least one other member of the household was incarcerated. However, the court gives little weight to this mitigating factor. The last mitigating factor set forth is that Bessman Okafor exhibited exemplary behavior in the courtroom. Counsel for Mr. Okafor suggests that the court take judicial notice that the defendant exhibited exemplary courtroom behavior. The court did note that Mr. Okafor followed the rules of the court and behaved as would be expected of any person in the courtroom, and especially a defendant during a majority of the trial. However, the same cannot be said of the post-trial Spencer hearing, which in part is part of the sentencing and trial process. During the hearing, Mr. Okafor did exhibit an outburst that required that the deputies react, that he be removed from the courtroom for a limited period of time, and that the court briefly recess the hearing. The court noted that the outburst occurred in response to an aggressive comment and action made by the victim's father, but nevertheless it did disturb the proceeding. The court does take judicial notice of the actions of Mr. Okafor both at the trial and at the subsequent hearing, but finds that it provides minimal, if any, assistance as a mitigating factor. The court gives very little weight to this mitigating factor. Those conclude the mitigating factors. The court has to address two other matters prior to getting to the sentencing. In this matter, the court must address proportionality from two different perspectives. The first deals with relative proportionality with regard to co-defendants who have previously been sentenced in this matter under the principle that equally culpable co-defendants should be treated alike in capital sentencing and receive equal punishment. The court requires, the second requires a consideration of the death sentence be considered, considering the totality of the circumstances of the case and comparing the sentence with that imposed in other capital cases. As to proportionality with the co-defendants, the issue of proportionality has been raised previously as a mitigating factor. It was the first one, I believe it was the first one, that maybe the second one that we went over. However, the court's going to address that briefly here. The premise of the defense argument is that, quote, the principle of proportionality precludes death against Bessman Okafor when it is not sought against the co-defendants Wallace and Godfrey, who were at least equally culpable, unquote. The evidence suggests otherwise because the other defendants in this matter were not, quote, similarly situated or, quote, equally culpable. The defense cites to the Slater case. In Slater, the co-defendant who actually shot the victim pled and was given a sentence of life. The appellant went to trial and was convicted by a jury, and subsequently a jury recommended by a vote of 11-1 that the individual defendant be sentenced to life in prison, not death. The trial judge, despite the recommendations, sentenced the defendant to death. In Mr. Okafor's case, the jury recommended 11-1 that the court impose a death sentence. In addition, Mr. Okafor's two co-defendants went to trial, each by a separate verdict, were convicted and sentenced to life. The state did not seek the death sentence in either of the cases at the time the case was tried. The evidence in this case has been set out above strongly suggests that Mr. Okafor was the trigger man. It also certainly proves that he was the planner, arranger, and the reason for the events leading up to the commission of these crimes. Therefore, the evidence suggests that the culpability of Mr. Okafor far exceeds that of any of the co-defendants. The defendants also cite to the Scott case. In Scott, the court quoted from the trial court's observations about the relative culpability of co-defendants. The court said in that case, as to the crime itself, they were both involved in all aspects of it. The trial judge further noted that the co-defendant Robinson concocted this method of killing the victims and that it was clear that this is not a case where Scott was the trigger man and Robinson merely an unwilling accomplice. Mr. Okafor was the one who concocted the manner of committing this crime. He was involved in the originating, organizing, recruiting, and execution of this criminal enterprise. He was also one, if not the only, trigger man. No evidence was presented that could reasonably be construed to indicate that the co-defendants, Wallace and Godfrey, organized, concocted, or anything to gain by this criminal act. The defense also points to the Puccio case. In that case, and I won't go too in detail, the case is differentiated because unlike Puccio, Mr. Okafor was the planner and the person who created this matter and the one who concocted the process that was to be used to kill or attempt to kill the witnesses. There are other cases which I will not go through in this matter. Let me move to proportionality as to other cases. The second proportionality factor requires the court to examine Mr. Okafor's case not as to the two co-defendants in this case, but as to other death cases or other cases in which death has been recommended or sentenced. The LeBron case has been cited by both sides, and the court has looked at the LeBron case. The LeBron case reminds us that this is not a calculation of the number of mitigators or the number of aggravators. We have to look at the total circumstances involved in this particular matter. In Mr. Okafor's case, unlike a lot of these other cases, there was no showing of any organic brain damage, brain injury. There's no showing of any tender age. There's no showing of somebody suffering from a memory impairment or being diagnosed with a severe mental illness at or near the time of the crime. There is no showing of any impaired capacity at the time of the murder, no showing of any impairment by drugs, alcohol, no showing of any remorse by the defendant, no showing of cooperation with the police or the prosecuting authority, no showing of physical abuse that transcended the early childhood. All of these have been dealt with in the LeBron case, the Freeman case, the Melton case, and the Miller case. Because Mr. Okafor was the individual who planned and researched the attack, recruited the personnel, arranged for the lookouts, orchestrated the assault on the home and the victims, participated in the shooting and killing or attempted killings of the victim, the court finds that the death sentence would be appropriate and proportional if imposed. The court has conducted its own review of the testimony and evidence presented during the guilt and penalty phase of this case. Having sat as the trial judge on this matter, the court has also had the opportunity to not only hear, but also to observe the witnesses as they testified, in this particular matter. and to weigh the candor and demeanor of the witnesses as they testified. After the jury weighed the aggravators and mitigating factors, it recommended by, after the jury weighed them, it recommended by a vote of 11-1 that this court impose a sentence of death. The court has conducted its own independent review of the aggravating and mitigating factors and the record evidence offered to support each of them. Each factor has been considered separately as to whether or not it has been proven by the respective standard, and further whether it in fact is mitigating or aggravating. Mr. Okafor has offered what amounts to 27 separate mitigating factors. Many of those mitigating factors overlap, interrelate, and merge into and with each other. Having considered each of the aggravators and mitigating factors in a qualitative and not just a quantitative manner, the court finds that the aggravating factors far outweigh the mitigating factors and support the recommendation of the jury for a sentence of death. The jury, having found Mr. Okafor guilty beyond and to the exclusion of a reasonable doubt as to each count charged in the information, it is the judgment of this court that as to each of the 4 counts you are adjudicated guilty. As to count 1 of the indictment, first-degree murder with the firearm of Alex Zaldivar, the court sentenced you to be put to death in the manner prescribed by law. As to count 2 of the indictment, attempted first-degree murder with the firearm of Brianna Campos, the court sentences you to serve a term of imprisonment in the Department of Corrections of the state of Florida for your natural life. As to count 3 of the indictment, attempted first-degree murder without a firearm, or with a firearm, of Remington Campos, the court sentences you to serve a term of imprisonment in the Department of Corrections for your natural life. As to count 4 of the indictment, armed burglary of a dwelling with explosives or a dangerous weapon, the court sentences you to serve a term of imprisonment in the Department of Corrections of the state of Florida for your natural life. The above sentences in this case are to run concurrent with each other and to run consecutive with any sentence you are presently serving. The costs in this matter, Madam Clerk, I believe they're $668, is that correct?
That's correct.
The costs in this matter in the amount of $668 are assessed and will be reduced to a final civil judgment. The clerk has advised me that you have 1,163 days credit for time served, and that will be awarded. You are hereby notified that you have 30 days from the date of this sentence in which to appeal the sentence and judgment of the court. This conviction and sentence is subject to an automatic review by the Florida Supreme Court. You are further advised that you have the right to counsel to assist you in preparation, filing, and argument of your appeal. If you cannot afford your own attorney, an attorney will be appointed to represent you. I believe I have already signed a notice of insolvency with regard to the appeal in this matter. State, are there any other matters in this case that the court needs to address?
There's nothing else that needs to be addressed. I have a form that Your Honor needs to sign.
Okay. Mr. Mosley, Mr. Anaku, are there any other matters that this court needs to address? My understanding for record purposes, the state is not requesting any restitution. Is that correct?
That's correct.
All right, thank you. Restitution will be waived in this matter. Ladies and gentlemen, as I've indicated, our deputy has some copies of some of the orders. We'll be happy to provide those to you. We will be in recess in this matter. Here is that order that is signed. I had to put it in an envelope, okay? And here's this. Yeah, I'm going to do that. Thank you. Sorry that took so long. You are. Thank you so much, gentlemen. We appreciate it. I'm sorry I didn't see the two you walk in. I apologize. Thank you all. Tough case, but it was a pleasure dealing with all 4 of you. We appreciate it. You're good attorneys.